Hello, my name is Ted Kirscher. I'm Vice President and Chief Operating Officer of Landrum Professional Employer Services. I want to welcome you to our webinar today about what employers can expect in 2012. I'm very happy to have with me today two guests, Amy Remington, who's General Counsel for Landrum Companies. Welcome, Amy.
Thank you, Ted.
And I have Todd Torgerson, who's President of Combined Insurance Incorporated with us. Todd, welcome.
Thank you, Ted.
Yeah, thank you. The purpose of our webinar is to address some of the very important issues facing employers in 2012. We'll talk about workers' compensation, we'll talk about unemployment compensation, we'll talk about some other important HR issues that are facing employers, and finally we'll have a discussion about healthcare reform and what it means to employers. We would invite you to send your questions to us. We're receiving questions via email at questions@landrumhr.com, and we'll address your questions on these topics at the end of our webinar. We'd also would invite you to visit our blog, landrumhrblog.com, where we frequently talk about many of the issues that we'll be discussing today. Our first topic is about unemployment compensation. And workers' compensation. Workers' compensation, as you probably know, is a state-by-state issue. Workers' comp is governed by the various insurance regulators in each state. Florida has had a workers' compensation program since the mid-1930s. And for many years, we had a very robust and healthy insurance market. Unfortunately, in the late 90s and early parts of the 2000s, we saw a dramatic increase in workers' compensation cost. That led to insurance reform in 2003, and we saw quite a decline in insurance rates from 2003 up to 2010. What employers can expect in 2012, unfortunately, is a workers' compensation rate increase of about 8.9%. This is an average rate across all of the employers in Florida, and we can give you some further details about individual industry groups in Florida. Manufacturers should see an increase of roughly 9.6%. The contracting community can expect to see just over 8.7% of an increase in 2012. Office and clerical group will see just over 7%. Those who work in goods and services will see nearly a 10% increase, and the miscellaneous category shows an 8.5% increase. Again, overall this is an 8.9% increase in our rates in 2012, but it's important to remember that this represents roughly a 58% decline in rates since the reforms were instituted by the Florida legislature in 2003. So it's unfortunate that we will see a rate increase in 2012, but I think it's probably in the best interest of the insurance market that we have this kind of increase in workers' comp. And now let's turn and talk about unemployment a bit. We talked last year about the state of unemployment both nationally and in Florida. So can you talk to us a bit about unemployment here in the country, Amy?
Sure. Let's start nationally first. Beginning about in fall of 2008 and continuing until this year, we've been, of course, in a recession, and we've seen unemployment continue to go up. The good news is that the national unemployment rate is 9.1% right now, which is about 0.5% lower than it was last year at this time. So we're starting to see a slow decline in the rate, and that's good news for everybody across the nation.
How about here in Florida?
The Florida average, the trend has continued like the nation. It's been a slow decline, but it is declining, and that's good. Last fall, the rate was about 11.7%, and this year in Florida, it's about 10.6%. Now, said differently, out of a workforce of about 9.2 million people in Florida, about 8.2 million people are employed, and it's just under a million people that are unemployed. So that's a good trend.
It sure is. Well, in 2011, we saw some changes in the Florida legislature that related to unemployment. Can you talk to us a bit about the changes the legislature implemented in 2011?
Sure. The governor has proposed some changes to the unemployment compensation statute. For starters, they're going through a rebranding process. The unemployment compensation statute is going to be called the Reemployment Assistance Statute if that change takes place. And the Agency for Workforce Innovation, which is commonly known as AWI, will become the Department of Economic Opportunity. So you'll see some rebranding done with the agency itself.
And what about the trust fund? We talked last year at our seminar or webinar about the insolvency of the trust fund here in Florida. What is the latest on the trust fund itself?
Well, the trust fund, as we said last year, it actually became insolvent on August 23rd of 2009. So it's been insolvent for quite an amount of time now. As of June of this year, the balance in the trust fund remained at zero. So what that means is that Florida has to make a choice. Florida either has to not pay unemployment claims, or they have to borrow money from the federal government. And like about 30 other states, Florida opted to borrow money from the federal government. So far, as of November of this year, the amount of money currently owed to the federal government is about $1.7 billion. And that, again, it seems like a really big number, and it is, but there are 28 other states that are in very similar situations. So we owe $1.7 billion to the federal government. And last year, you'll recall, we had a $61 million interest payment that was due. Much of this interest was paid by employers in the state of Florida this year through a special assessment where all employers paid about $9.60 per employee. Mm-hmm. So most of the interest is being paid down, and that's going to help us knock the principal down as well.
Mm-hmm. Let's talk a bit about rates in Florida, the tax rates in Florida.
Sure.
What's happened, let's start with the minimum rates. What's happened with those rates here in Florida?
Well, the minimum rates have changed significantly. When the recession began in 2008, the first thing the legislature did in response was to raise the tax rate for the we're talking about state unemployment taxes now. The state legislature increased the minimum rate to, it was $8.40 per employee, and in 2010 it took a jump to $25.20 an employee. The following year, in 2011, it increased to about $72 per employee. This year, it's projected that on January 1, both the minimum tax rate and the wage base will go up. So the tax rate will increase in its percent, and the wage base will go up, meaning that instead of paying taxes on the first $7,000 of employment, employers will pay it on the first $8,500 of employment. What this means to employers, the bottom line, is that it's going to go up to about $171.70, the minimum per employee per year.
So we've seen the minimum rate now we're talking about going from just over $8 per employee to now up to $171 per employee?
In about 3 years, yes.
Wow. Now, so far the discussion has been on the state of Florida's tax rate. What about the federal unemployment tax rate?
Well, the federal unemployment tax rate is set in large part by how much we owe the government, if we do owe the government anything. If the state owes the government money, then we lose a federal unemployment tax credit that we get. And there's a specific formula for how this is derived. But again, what it means to the employer, the bottom line is that because we owe money to the federal government, the state of Florida federal unemployment taxes that are paid to the federal government under FUTA, that will also increase.
Well, is there any good news out there?
There is some good news out there. The good news is that because we have been paying so much for so long, for so many years, the legislative projection is that the downward trend in the tax rate will continue until 2018, when it is then projected that the account will not only be solvent, but that all of the loans and the interest will be paid off. And hopefully in 2018, it's projected that we'll be back down to that $8 to $10 range per employee. So we're seeing a very dramatic spike, and then for the next several years, it's going to go down gradually. But it's going to do that so that we can pay off the federal government's loans, get our FUTA tax credit back where we want it to be, and replenish the account entirely.
Well, that's certainly good news, but it's going to take us a while to get there, I guess.
It will take a while to get there.
Yeah. Let's talk about other issues that face employers. I know we've got a lot of other topics to cover in that regard. What can we talk about changes for employers in 2012?
Well, one of the most significant and most immediate changes is a new posting. We often tell our clients about the new posters that are required if we have any changes to things like minimum wage. One significant new posting that almost every single employer needs to be aware of is a National Labor Relations Board posting. And even if you're a non-union employer, you are probably under the jurisdiction of the National Labor Relations Board. And if you are, you have a new posting required. And it's very specific in terms of the size it has to be, and the language it has to be in, and how many you have to have, and where they have to be posted. And what this poster tells, it tells all employees, is that they have the right to organize and to bargain collectively, and to engage in other protected, concerted activities, specifically including discussing compensation in the workplace.
And we've got a sample of one of these posters here, so our audience can get an appreciation for the size of this poster. But actually, the requirement, it spells out exactly the size this poster is to be.
It has the size, the font, the language. It has to look exactly like this, or you're automatically out of compliance.
Gotcha. And where could employers find a copy of this poster?
Well, it's available for free from the National Labor Relations Board on their website, or Landrum has it for free as well.
Okay. Are there any things employers ought to do to be proactive in this regard? What should employers do to try to stay ahead of this curve?
Well, this is a poster that tells employees what their rights are in the workplace. There is no prohibition against employers posting what's called a counter notice, and that would be a notice to employees that says the individual employer's stance on unionization and why a union may or may not be beneficial in their workplace. Again, it has to be very specific, and so if somebody is going to post a counter notice, I highly suggest that they have an experienced employment law attorney look at that, or their human resource professional, because you don't want to run afoul of any National Labor Relations Act laws, even if it's unintentionally.
Right, exactly. We're going to talk next about social media, but I want to remind our viewers that we do have a blog, LandrumHRblog.com, that we'd invite you to look at. We'd also invite your questions at questions@LandrumHR.com, and we'll address them at the end of our webinar. Amy, let's talk a little bit about social media and about the trends in the workplace regarding social media.
Well, these tie in neatly to the conversation we just had about the National Labor Relations Act. There are many new cases out, and this is a whole emerging area of employment law that 5 years ago didn't exist. But there are many cases out right now where the trend seems to be very employee-friendly and not employer-friendly. And I'll give you some solid examples. There are cases out right now where an employer goes on a public website such as a Twitter or a Facebook or one of those, a blog or whatever it is, and posts something. And some of the specific examples include calling an employer names like scumbag was used in one, psycho was used in another. Another one was where an employee went on his or her Facebook and talked about how inexpensively the company used a promotion. And so they said really negative things about the people that worked for the company and the company practices. And in each of those situations, the employee was fired. In each of those situations, the National Labor Relations Board looked at the case and said, you know what? This was tangentially related to employment. It was arguably for the benefit of other employees, and it affected the terms and conditions of employment, so they ordered reinstatement and back pay for every single one of those cases.
So is this like an official position now? Does the National Labor Relations Board, have they taken an official position on this subject?
They have taken an official position, and they have a guidance out that's very, very informative. It's the General Counsel's report. And what the General Counsel's report says is that where an employee engages in any sort of protected concerted activity that is for the benefit of other employees, that is probably protected. And it gives specific examples of cases that most employers would think were reasonable reasons to terminate somebody, but the National Labor Relations Board said no, you have to reinstate them and give them back pay. And they list probably 4 or 5 different very specific cases in that Attorney General memorandum.
So what kind of advice would you give employers about how to deal with this?
Well, I think one thing we always talk about is policies. I think well-written policies are a must for fair and consistent expectations of employees. But now, again, didn't exist 5 years ago, now I think every company should have a social media policy. And that policy should emphasize the respect of individuals, and it should talk about consistent practices. It should have mutual protections for the employer and the employee. For example, an employee may use Facebook or Twitter, that's not a problem, but there should be no disclosure of confidential information. And in using those websites, the employee should remember that it's akin to using a Sharpie and putting it on a billboard. It's not in a pencil form anymore that can be erased. Once it's out there, it's public and it's permanent. So I think as long as the policy emphasizes mutual respect, employees are in good shape. But they should also have a catch-all at the end that specifically says that the law always trumps the policy, and if the National Labor Relations law changes, that will always trump the policy, because the law is evolving so quickly that not to have that catch-all would mean that you'd literally have to revise your policy once every other month.
Gotcha, exactly. Well, that's great advice, Amy. Thanks for that. Todd, let's talk about healthcare reform for a bit. That's another issue that's really on the minds of employers, I think. There's been, I guess 2012 would mark the 2nd year of healthcare reform, so what should we be expecting in 2012?
That's right, Ted. You know, if you read or watch the news, you know that healthcare reform is clearly one of the most dominant social and political issues of our time. While 2012 is going to be a relatively quiet year, I think, for employers, There are a lot of things that are left yet to be determined. There's questions about the implementation of the law and even the viability of the law. When you look, there's three key things. One is that there are still many rules and regulations that have yet to be determined. And the constitutionality of the law, as you know, in 2012 is going to be challenged in the Supreme Court. And then finally, we have the November elections that are coming up, and that's going to have a profound impact on the legislation that we know it as today and for future healthcare legislation.
Mm-hmm. So what about insurance companies? Is this going to be an active year for insurance companies?
Oh yes, they've got their plate full right now, and there's a lot of issues that they're having to pay attention to that are going to require their immediate attention or implementation. Among them is the standardization of benefit summaries, and the idea here is that they would be able to, or be required to rather, have benefit summaries that are understandable, easy for people to understand and read. But the good news is that the government has announced a delay in the requirement, and it was originally scheduled for March, and now it's been delayed, and we don't know what the new date will be. But as you know, sometimes things made by committee turn out more difficult than they were originally sought to make simpler. The insurance companies are also going to have to go through a special review for processing, or process rather, for rate filings that are deemed excessive by the government, and right now that's 10%. Of an increase. For any filed rate increases, they're going to have to go through a special rate review process. And then for the, the pressure, there's also pressure on the insurance companies to put a more clearly defined appeals process in place for their claims appeals. It's going to help, I think, standardize and systematically make things better.
I think there's been a lot of concern in the press, I think, about insurance companies and their cost. What are insurance companies doing to lower their cost?
Well, that's one of the most contentious pieces of this legislation, and it really gets down to the medical loss ratio requirements that are included in the law. And what they're attempting to do significantly here is to say that they're going to put a cap on what the insurance companies can make by limiting the amount of premium they can keep as a percentage of their overall revenue. And the way it plays out in real life here is that for individual and small group cases, in aggregate, if the loss ratio is over 80 or under 80%, or for large groups if it's under 85%, the insurance companies are going to have to provide a rebate back to the insureds, both the employer and the employees, based on a pro rata share of their premium. It's yet to be determined. There's a lot of things that are still going on with the medical loss ratio in terms of what counts. But for example, right now, if a large group block with a large insurance company had a loss ratio of 80%, employers and their members would be due a 5% refund of premium each based on their pro rata share.
Well, gee, I mean, the idea of a rebate from an insurance company sounds good. Is there something we ought to be concerned about?
Well, there are some concerns with the law, even if you get past the philosophical bridge of regulating the profits and expenses of private industry, which is really what we're talking about here. It does mean, though, that the insurance companies are going to have to find ways to lower their cost. And that's not necessarily bad, but what it could mean is that we're going to see some services cut that we've become accustomed to having. Mm-hmm. The other thing is that I believe strongly that there is the potential for an unintended consequence here for the insurance companies to be incented to raise their rates. After all, 15% of more premium creates more dollars.
Mm-hmm. Very true. What about the way we acquire insurance? Is that likely to change as we go forward here?
It very well may. Part of the law calls for each state to create what we call a health care exchange, where small businesses and individuals can go to what is essentially a virtual marketplace. I think if you were around in the 1990s, early 90s in Florida, you may have seen the Community Health Purchasing Alliances, or CHIPAs. And the concept is basically the same. It didn't work out very well in the 90s, so it's yet to be seen how things are going to play out here. But many states, including Florida, are pushing back on the program, citing the court cases that have already made the law unconstitutional.
What about grandfathering, Todd? We talked in our seminar last year about grandfathering. Can you talk a bit about the current thinking on grandfathering?
Yeah, that part of the law says that you could keep your plan and if you didn't want to make any changes to it. But the problem with that is that you would have to keep your benefits essentially similar. You couldn't make very much change at all. and you couldn't reduce your premium contributions as an employer by more than 5% as a percentage of premium compared to what you had in March 23rd of 2010. So that's made it impractical for a lot of employers to be able to do that. So most employers have abandoned the idea of being grandfathered, and they're moving ahead because they want to be in charge of their contributions and their benefits. We are keeping a watch out, though, for the non-discrimination rules that are going to come out. Non-discrimination testing is applicable to non-grandfathered plans. And it was scheduled to go into effect earlier, but it has been delayed because there's a lot of complications with it.
But there are some positive things, aren't there, Todd, out there as we look in 2012 for small businesses?
That's right, there sure are. One of them, I think, is one of the best ones, is that if you're an employer with under 25 employees and you have an average salary of under $50,000, then you could be eligible for a premium tax credit. And the $50,000 average salary does not include the business owner. That's just the employees. So it works on a sliding scale, which is up to 35% of the premium. And so that means that smaller firms with lower payrolls are going to be the ones that get the highest reimbursement. There's been a lot of confusion, I think, about W-2 reporting and about benefits and the taxation of benefits and all as it relates to W-2s. What do we look forward to in 2012 related to W-2s and benefits? There has been a lot of confusion about that, and it is important to note that, at least for now, all we're talking about is reporting the cost of benefits on the W-2. At this point, the premiums are not going to be considered taxable income. That's where the confusion has been. There's also been some questions about when this needs to occur. And for 2012, employers that issue more than 250 W-2s will need to prepare for 2013 issuance. If you have fewer than 250 W-2s issued, then you have another year delay.
But this is simply reporting, not taxation. That's
exactly.
a clear distinction, right, Todd? Let's talk about health savings account and flexible spending accounts. There are some changes impacting those accounts, are there not?
Well, there are a few. When you look at HSAs, aside from the elimination of the over-the-counter drugs being a qualified expense and moving the penalty for non-qualified withdrawals from 10% to 20%, we've really experienced no remarkable change to the HSA. I think it's still a very, very viable product. I think it's one of the best things going on in the market. If you are an employer and you have a health flexible spending account, however, for 2013, the limit will be $2,500. So if you're an employer with one of those plans in 2012, you're going to be needing to prepare your plan documents during that year to be ready for 2013.
Well, you've said, in spite of all of this, Todd, you told us 2012 was a relatively quiet year. I think everybody's looking for 2014 as the big year as it relates to health care reform. What should employers be doing now to sort of get ready for 2014?
Well, yeah, 2014 really is when the legislation hits full stride, and that's when employers with over 50 FTEs are going to be subject to certain provisions of this law.
Full-time equivalents.
Full-time equivalents, not full-time employees,
right.
Because there's a formula that takes into account the number of hours part-timers work. So just because an employer has fewer than 50 full-time employees does not mean that they are necessarily exempt from some of these provisions. The first thing that an employer is going to have to decide, if they do have over 50 full-time equivalents, is whether they want to offer a benefit plan at all. If they don't, then there will be a $2,000 fine for every full-time employee after the first 30 workers. Even if you offer a plan, Ted, there are further penalties based on the individual employee's eligibility for tax credits or subsidies. An employee is eligible for a tax credit if their family income is less than 400% of the federal poverty level, and that's $88,000 for a family of 4. The benefit plan, if it's deemed insufficient, or if the employee contributes more than 9.5% of their household income toward the cost of the insurance.
So it's possible to offer a plan and yet still have issues? That's
exactly right. If your contribution as an employer is not sufficient or your benefit plan is not sufficient, then there's a further penalty, is the lesser of $3,000 per subsidized individual or $2,000 per employee.
So what do you recommend, Todd, as to get ready for this? What should employers be thinking about now?
Well, I think first is that 2014 is a ways away. I think we've got to just take a breath here and ask employers to focus on the implications of today's issues, but think about the future for 2014. If you're a large employer, it's almost as if you need to know what to do today in 2014. But for most employers, particularly in this area, that's not a requirement, given the fact that there's a lot of uncertainty, there's a lot of probable change that's going to occur between now and then. Employers do need to focus on aligning their company goals with their benefit strategy to make sure everything's in sync and that everything's headed in the same direction. And I truly believe that all employers, regardless of their size, should be engaging their employees in wellness, because it's so much less expensive to be well than to be sick. And it's been proven that 60 to 70% of all medical expenses are behavioral or lifestyle driven. But finally, right now today, you can make sure that you understand the full scope of options that you have, and I would encourage everyone strongly to take a look at a program like Landrum.
Great. All right, well, thank you very much, Todd. That's great advice for us. Again, we've asked you to send your questions to us. You can email those questions at questions@landrumhr.com. We have some questions that we'll address now. The first one is, can you give an update on the 1099 requirements in 2012? I think this might be related to the health care legislation and the requirement to report over $600. Todd, is that?
That's right, Ted, yes. There was an original part of the legislation that said if you're an employer or a business and you do over $600 worth of business with any vendor, then you're going to have to issue a W-2, or a 1099 rather, for that amount.
Right.
And fortunately, that part of the law has been repealed.
Great, that's great news. Our next question that was submitted to us at questions@landrumhr.com is there a change in 1099s this year?
In W-2s this year?
No, the question is 1099s, and I think that might have been related back to Todd's thoughts. I think, yeah, so right, there's been no change there. Our next question is, do you have to include the insurance paid by employer on the W-2 for 2012?
The answer to that is not this year. That's the good news. That was in the original PPACA, which is the health care legislation. However, that has changed and it has gone back to 2013. So what that means is in 2013, those W-2s will include all the wages for 2012 as well as the value of any benefits. And that's what Todd spoke of when he said they're not taxable, but they have to be on there for informational purposes.
Very good. Well, that appears to be all the questions that have been submitted to us so far. If you have questions and would like for us to address them, you're welcome to send them to us at questions@landrumhr.com. I want to thank my guest, Amy Remington, General Counsel at Landrum, and Todd Torgerson from Combined Insurance for being with us.
Thanks, Ted.
Again, we hope that you've got a sense of what you need to be prepared for in 2012. If we can assist you at Landrum, please be in touch at landrumhr.com. And as I said, continue to send us questions and also check our blog at landrumhrblog.com. Thanks for tuning in.